All right, thanks, Andy. So yeah, my name is Jake Old. I'm a staff attorney here at West Tennessee Legal Services, and today what we're going to be talking about is my client judgment proof? And so that's going to mostly be, I mean, it's kind of a black and white issue, but as we'll kind of dive into, there's a lot of gray area in here. And we're going to have a little bit of just background about civil judgments and debt and that sort of thing and how it can impact indigent clients. A little bit of help with issue spotting. And so my goal is that anyone who is watching this presentation will be a little bit better equipped to kind of identify these issues and how they might impact indigent clients or even clients that are kind of on the border, maybe indigent, maybe not. I've also on this slide included a little bit of information about myself because when I attend presentations like this, my first question is usually, who is this guy and why should I be listening to him? But my focus area is consumer protection, consumer rights litigation. And so I'm a little bit of a specialist in this area, not necessarily an expert, but this is kind of what I do day in and day out. Um, as a threshold issue with when I talk about judgment proof, I am thinking about civil judgments, things like debt collection, not stuff like child support orders, which have special rules and could be their own separate presentation. So I'm not going to dive into that stuff. I'm going to focus on civil judgments. And so when we talk about this phrase, it really means someone who is in a situation where they have such little income and assets that even if a creditor or another individual gets a civil judgment against them, they can't compel them to repay through a garnishment, through a lien, or through executing on their personal property or any other assets that they might have. And so that means even if they win in court, they're essentially going to get a piece of paper that says this person owes me money, and they're not really going to be able to do anything with it. They'll be at the mercy of the defendant, the debtor. What it doesn't mean is it doesn't mean that a person can't be sued. And that is a misconception that I see with my clients very often is they hear the phrase judgment proof and they just do the mental calculation of that means you can't take me to court. And that's not what it means. And I know everyone on this call probably knows that, but that's just something I point out because that is something that a lot of clients, in my experience, have just had a sort of fundamental misunderstanding about is they think judgment proof, you can't sue me, you can't take me to court. So sometimes when I talk to clients, I'll say collection proof because that's a little bit more accurate phrase. It's not the legal term, but it's really you can't collect on a debt. You can still get a judgment. And so just a little bit of background for people that don't work a lot with indigent populations and might not be familiar with how these situations arise. I've listed a few general examples of how these types of debts can happen for people that are judgment proof. One is that indigent people are often targeted by predatory lenders who are looking to take advantage of them and they get lines of credit and loans that they really never could afford to pay back, and they have astronomical interest rates. There are also, situations where someone might not be what we would term as indigent, but they don't have access to health insurance, and then they have a health emergency, and now suddenly they have huge health bills. Or it could be someone who has debt that they can manage, and then they have some sort of huge life change, some sort of event that puts them in a situation where suddenly they can't handle the debt, and it becomes overwhelming. Debt collectors and creditors often cast a very wide net when they litigate cases, not just against indigent people, but against everyone. I mean, they file tons and tons of cases. If you ever go to a civil docket call in general sessions courts, I mean, depending on the size of the county, you'll see dozens, sometimes hundreds of the same creditors often suing people, just one after another after another. And because of the business model, it doesn't really make sense to do a lot of individual, research on, is this person judgment proof? Does it make sense for me to go after them? Because it's usually, one or a handful of attorneys handling all of these cases. And so they're able to kind of cast a wide net. And so that's one big reason why a lot of indigent people end up in litigation for something that could never be collected from them anyway. Unfortunately, we do have some protections under state law for indigent people, so they don't lose literally everything. Some of those are things that the individual has to assert to protect, and some of them are just sort of statutory, inherently things are protected, like the clothes on your back and your family Bible and things like that. You don't have to assert a protection for those. That's just sort of state law protects that. And the idea is that it's the bare minimum of living is what we want to make sure someone can't have, literally everything taken from them to pay a creditor or something like that. Um, in general, debt collectors and creditors will try to collect in one of three primary ways. And this is not really a debt collection, seminar. I'm sure people who are in that world could identify other, more niche ways, but big one is garnishing their paycheck. Another is putting a lien against real property, any real property. It could be their home. It could be, if they have an interest in some other sort of land somewhere. And then the last is executing a levy against a bank account that the consumer owns, or if they have any kind of valuable personal property, they can execute on that and force the sale of it. Normally, that would only be something like a vehicle. Usually, people who are in these situations don't have significant personal property other than that. And so these methods are not exclusive. They're more often than not used in conjunction with one another. And another note that I've put down here is that these are things that it's after you get the judgment, and when the creditor has the judgment, it's probably going to be generating post-judgment interest. It can be set by contract. Sometimes you'll see contracts where they say whatever the interest rate is in the contract is going to be post-judgment as well. But the default right now in Tennessee is 10.5%. It's updated every 6 months. It's getting ready to be updated again. It looks like it's probably going to stay the same. And that 10.5 is really high, and it's actually the highest that I can see Tennessee has ever had. It has a lot of factors that go into it, and one of them is inflation. But they publish that every 6 months, and so we'll have an update on that pretty soon if that changes. So when a creditor is going to try to collect, how do they, like I said, they don't really do a lot of recon on this, but how do they get this information? Well, sometimes the information is publicly available. Property records can show that someone is a homeowner. But if the creditor doesn't know where the debtor works, what they own, anything like that, they can file a motion with the court after they have a judgment to have a debtor's examination, which is basically just where they have the consumer under oath and the consumer has to answer a ton of questions related to collection at the judgment. They can also, instead of doing this in a hearing, they can submit interrogatories, and it's compelled. The debtor has to have a really good reason for not providing the information. And I've listed some of the more common things where you can get that information from people. It's, what do you own? Where do you work? Your banking information, tax returns. And if a debtor fails to appear at a debtor's examination or doesn't comply with the subpoena, it's just like any other subpoena, there could be sanctions. So that's something to keep in mind, because with indigent clients, they still will get subpoenaed for a debtor's examination because the creditor may not realize that they're indigent. Okay, so a little bit about garnishments to start. The first threshold issue that I always think of is, are you dealing with a private creditor? So this is going to be like a credit card company or just an individual, just anyone who is suing someone else in state court, or is it the government? Because there is a little bit different rules for the government. And the most significant one is that a private creditor can't garnish Social Security. They can't garnish government benefits. The government, however, in certain situations can. I'm not going to dive too deep into that, but that's just a good thing to identify is if it's a case where, someone has back taxes that they owe, the IRS is going to go after them, and they have a lot more leeway to go after things than a private creditor does. But the general rule for a private creditor is they can take up to 25% of the weekly pay for someone who makes more than $217.50 per week. And as a client pointed out to me recently, if you work, you probably make more than $217.50. The only situations where I've seen someone who is actually employed and making less than that is when they work part-time and they make a pretty low hourly wage. But yeah, it's just something to keep in mind is that the government, if they are acting as a creditor, they can garnish some benefits in some situations, and they can also do a tax offset to seize an income tax refund. But they are not limited to just that. They can also use any regular thing that a private creditor could use. They could garnish the paycheck normally. They could put a lien against your home. And obviously, if a client has no income, they don't have to worry about garnishment. They probably have bigger issues though. So liens, just a little bit of an overview on that. A creditor who gets a judgment can send a certified copy to the Register of Deeds in that county, and it places a lien against any property that the individual owns in that county. And it also will be with the Register of Deeds, so if they acquire property in the future, they can put a lien against it at that point. If a creditor wants to enforce a lien, they can force a sale in Chancery Court. There is a real practical reality with a lot of these cases because if there's a mortgage against the home, that's going to take priority, and so the creditor might not be able to even force the sale, and if they can, they might be wasting their time. There could be other liens as well that have priority. And another sort of practical thing is in my work, I have worked with attorneys who represent creditors, including a lot of credit card companies, and they have just told me straight up, if there's a credit card debt of, let's say, $5,000, there's no way this credit card company wants to get a reputation of being a company that makes people lose their home over a $5,000 debt. But it is important for the client to know that this is how a lien could be enforced, so that they have all the information to them, because you never know if it's like an individual who sued them who gets a lien against their home. Maybe they're a little more willing to enforce it. And then obviously, if the client doesn't own real property, a lien is not going to work. But also another thing to keep in mind is if the client has a gigantic mortgage, the lien is really not going to have much impact for the creditor. And so usually, the creditors just get the lien because it's better than not having the lien. And that way, if the client someday is in a position where they can refinance or they can sell the home, the lien is there. And theoretically, that's an opportunity to get paid. The last thing we're going to go over with these three primary types is executing on property and cash. And so personal property, it's actually a sheriff's sale, the way that it gets executed. And they sell it at an auction, and then that goes towards satisfying the judgment. And so there's two different executions that they can do that I just mentioned on personal property, or they can just levy an execution against a bank account and just take any unprotected money that's in a bank account. So state law, starting July 1st, will automatically protect $2,500 from being taken in an execution on a bank account. Separate from that, individuals can also protect up to $10,000 worth of personal property and accounts by filing a personal property exemption list with the court. And we'll go into more detail about that. because the $2,500 thing hasn't gone into effect yet, it's not really clear how that's going to work, but it does seem like from the phrasing of the statute that these are going to be working in conjunction. So you're not going to be able to have your automatic $2,500 protection plus 10,000. It's going to be a total of 10,000, but you don't have to do anything to protect that 2,500 in your bank account. It's a little bit confusing, and it'll be interesting to see how it plays out. The last thing I want to note here is just to keep in mind repossession is a potential remedy in certain types of cases, like a car loan, where you could risk repossession of collateral if you don't pay your loan on time. Sometimes this is something that happens with judicial assistance, sometimes it is without. Often, especially with car cases, they don't go to court for the actual repossession because they have a security interest and they can enforce it through their contract. Sometimes the creditor overlooks that, or the way that the contract was phrased wasn't great, and a different attorney comes in now and says, well, no, wait, we can't do this. And so sometimes you'll see people getting taken to court for effectively a repossession. But the assessment of when you're looking at, is this person judgment proof, you should think about for this specific debt as well as just in general. It's not just, this person doesn't have any income, this person doesn't own a home, they don't stand to lose anything. They might stand to lose nothing for 90% of their debts, but for this one debt, if they don't pay it, they're going to be in real bad situation because they're going to lose their vehicle. So that's the way that I think of that sometimes, is looking at this as sort of a threshold issue and separating it from just the general, is someone judgment proof? Okay, and so this is a little bit of, I've covered this a little bit, but it's just stating it all in one slide, that garnishments will fail for private creditors if their only income is a benefit, or if the individual makes not enough to hit that $217.50 per week limit. And for the government, a little bit different rules. For liens, if a debtor doesn't own real property, it's going to fail. And if they have a mortgage, the mortgage is going to take priority, and sometimes in some situations the creditor won't even be able to try to force a sale. And then for execution, if the debtor doesn't own valuable personal property, execution will fail. And similarly, if they don't have a bank account with money in it, or with more money than the limit, then that's going to fail as well. So there's also gray areas that I kind of want to just draw your attention to. Garnishment of pensions and private retirement plans. So not Social Security, but like something through an employer provided. Generally, these things can't be garnished. Pensions normally can't be garnished, and retirement accounts normally can't be garnished. And I've listed the authority there where you can dive into that. But it is fact specific, and there are certain situations where things can be garnished. But the real thing to note here that I've seen my clients run into several times is at the bottom of the slide, and that is Social Security is exempt from a private creditor taking it, but there is conceivably a situation where the debtor can get in trouble. So if the debtor has an account where their Social Security is deposited, and then they take it out of that account and they put it into a different account, that could conceivably be executed against and taken. And so I specifically had a client who had opened up a savings account, and they were putting just a little bit of their Social Security in there every month. While the bank looks at it and they can't trace it to see that it was a Social Security deposit because it's coming from a bank account and not from SSA. And so they let the creditor take it. And it's a little bit more difficult to argue that that is Social Security. There's a lot of paperwork. Usually the creditors are pretty good about recognizing that they probably shouldn't have taken it and giving it back. But it's case by case, and the client can get in a lot of trouble. That client would have been better served by knowing on the front end that's a dangerous thing to do. And there are ways to protect that income that we'll go into later. There are ways that an indigent person who has just like $5 left over can put that in a savings account ostensibly. That's just something I want to call attention to. So I am a person who likes flowcharts, and so I have put this together as a way to kind of think through these issues that we just covered. First is this threshold issue is repossession. Does the client stand to lose something by not paying this debt before it ever gets to litigation? And so that's pretty specifically for something that can be repossessed. And if the answer to that is yes, obviously they are not judgment proof for that debt. Does the client own a home? If yes, then they're not judgment proof because a lien could be placed against it. Then, does the client have cash or assets that exceed $10,000? If yes, not judgment proof because then they stand to lose something by not paying the debt. And then the last one down here is, does the client make more than the minimum amount per week in take-home pay? Obviously, if yes, they're not judgment proof. If no, you probably still need to take into consideration some of these gray area topics that we've talked about, retirement accounts and that sort of thing. But otherwise, they're probably judgment proof if you go through all of this and you still get to that. But always remember, if you have the weird case where the government is acting as a creditor or a debt collector, they could still be subject to tax offset where their income tax refund is taken, and there is sometimes the potential for benefits to be garnished. So this is generally when I have gone through everything and I've been talking to the client and I've determined the client is judgment proof. This is usually the type of things that I will tell them. Income can't be garnished because it's too low. You don't even have income to begin with, so obviously it can't be garnished. Or your only income is a government benefit that can't be garnished by a private creditor. Don't own a home, so you don't have to worry about a lien being placed against it. And then your assets and cash are 10,000 or less, so we can't help you protect those assets under state law. And essentially, the creditor is really at their mercy. If they think they have enough money to pay something per month, then the creditor's got to take what they're willing to give because they don't have any way to compel payment. But I always tell my clients, you probably shouldn't pay them anything because you don't stand to lose anything by not paying it, and you're indigent. You're barely making ends meet if you are making ends meet. So if you think you have $20 a month to pay this creditor, keep it, pay it towards something else, your living expenses, your food, your utilities, whatever. That's usually what I tell clients in these situations. And now it's also important to note that if their status changes in the future, if they get a new job, they get a promotion, they get new property or assets, that changes things. The creditor will be able to potentially garnish income or place a lien against property or execute against property. Judgments are valid for 10 years, which is kind of a misleading thing because you can renew it after 10 years and you can keep renewing it until it's paid or discharged. And there's the potential for post-judgment interest. So if their situation changes later, if that judgment has been drawing interest, it could be a lot bigger than it was at the initial time it was obtained. And this is a quote at the bottom that I've used with clients who they love this quote. Can't squeeze blood from a turnip, which is essentially just sort of underscoring the fact that the creditor is sort of at their mercy. They can't force them to pay something because you can't force someone to pay when they don't have the money to pay to begin with. That's just something my clients, when I say that, that's usually what makes it click for them, is that quote, because they probably heard it before and they can kind of connect those dots and say, okay, that makes sense to me now. So what do creditors do when they are in this situation with someone who is judgment proof? Well, they usually still want to get that judgment because of, like what I just said, you never know when someone's situation might change. And if they already have that judgment, then they can collect in the future and they don't have to worry about any sort of statute of limitations issues or anything like that. If they're able to register as a lien, they're going to want to do that. But sometimes they will consider what they call hardship waivers, which is basically where they recognize that someone has a significant hardship in their life. Usually it's a disability. Sometimes they'll do it for folks who are elderly, especially if they're in like an assisted living facility or something like that. And they recognize that this debt is probably never going to be paid. And so they will cease collection activity. Not necessarily formally forgive the debt, but they'll just stop trying to collect it. But we also like to warn our clients about. Sometimes creditors will give sort of misleading statements to individuals to get them to pay per month. And the creditors will still want to get that judgment so that they can use it as a threat. But if the client is judgment proof, there actually is nothing they can do. It's an empty threat. And so we always want to make sure clients are aware of that, because it may not even be intentionally misleading on the part of the creditor. It might be that they don't really realize that the person is completely judgment proof, but they will try to use it as a way to coax someone into making these monthly payments that really it can't be enforced, and it's going to make this person, this indigent person, the quality of life significantly less. They're going to be doing without. They're going to be going without something that's probably necessary, and they really don't need to do that. And so, a lot of situations that I have, the client is actually not judgment proof, but they're maybe really close to being judgment proof. They're just barely not. And so, what do I do for those people? Because those people need help too in a lot of situations. So, if they stand to lose cash or personal property from an execution, you can file what is called a personal property exemption list with the court where the judgment was obtained. It's got to be filed within 10 days of the judgment being granted to protect the property, but that shouldn't deter anyone from filing it later if they miss that deadline, because that just is, you want to get it filed before the judgment becomes final. And in general sessions court, where a lot of these things are happening for indigent clients, that deadline is 10 days because that's when the judgment becomes final. Obviously, in different courts, it's going to be different deadlines. You're going to use the rules of civil procedure, but even if you miss that deadline, all that is guaranteeing is that the property or cash won't be taken on an execution as soon as the judgment becomes final. It is possible that the creditor doesn't know that those things exist and doesn't know to execute it. And so you might still be able to file it later, but it's protected from the moment that you file it. And they may need to file another one in the future if something changes, if they get a new car or something like that, or they open a new bank account. If someone has a lien against their property, like I mentioned earlier, I will always advise them that the creditor can theoretically force a sale, but really they should look at the practical implications of whether that's going to happen, and if it happens, will that really do anything for the creditor? And then there's the homestead exemption, which if a sale is forced, there is an amount that is held out for the homeowner to go toward their next home. And so that all kind of adds together to that practical question of will the creditor actually try to force a sale? So if someone is being garnished, and this is something that we see a lot, is they can file a slow pay motion. And essentially that puts a stay on the garnishment, and it gives the debtor a chance to request a monthly repayment amount ordered by the court. And obviously it's going to be something lower than what the garnishment amount is, but it's something that the debtor can afford. And so the last ditch effort in these situations always should be considering bankruptcy. I'm always telling clients it's something that you will need to consult bankruptcy attorney if you have a ton of debts, if you stand to lose something by not filing bankruptcy. But a lot of times clients kind of get it in their head, I have a lot of debt, I need to file bankruptcy, but if someone's judgment proof, no, they don't need to file bankruptcy. If someone is close to judgment proof, they still probably don't need to file bankruptcy, but it's a case by case basis. And a lot of clients, they kind of come in with that in their head, and I always tell them that's the last line. Let's go through all these other things we can do to protect your income and assets, and then if none of that is going to work for your situation, then that's your last fallback. So this is from one of our brochures. It's very tiny. I don't intend for you to actually read through this or anything. I just posted it so you know this is what the form looks like. This is the personal property exemption list. And after this slide, we'll go into detail on what is actually included in this list. So main thing up front is protections for bank accounts that only have deposits from a protected source. And remember, when we said protected source, this is something that a private creditor can't garnish under any circumstances. So this is like Social Security, SSI, something like that. Importantly, that does not count towards your $10,000 of protection. So this is an account where the only deposits ever are coming from this protected source. So if you have a client who is getting Social Security and that is the only thing, that's this bank account. If they're getting Social Security and there is some other type of deposit that's happening regularly in this account, then they're not going to be able to do that. So then after that line, you have protections of the $10,000. So it includes estimated value of any automobiles that they own, furniture and appliances, household goods, other personal property, and then other bank accounts that aren't just government benefits. With these, I have never actually seen a creditor who tries to execute on furniture and appliances and household goods. So I usually tell clients they don't have to put anything there unless there is just like a piece of furniture that is really valuable that they really, really don't want to risk losing. But it would be very odd if a creditor wanted someone to sell their couch or something like that. So I usually don't focus on that stuff too much. It's usually the big ones are the automobile and bank accounts. That's the big things for me. But there's lines there for those too. It just all has to add up to $10,000 or less. There's a separate protection of up to $1,900 for tools of the trade. And that is not included in the 10,000. That is a completely separate thing. I have never had a client who was indigent who had tools of the trade they wanted to protect. So I've never actually used that, but it is there to be used. Practical tip here at the bottom is if you're filling out one of these forms, there's not any reason not to use the full 10,000 that the client gets. So if the client has $200 in the bank and they have a car that's worth $3,000, then maybe overshoot the value of the car, overshoot the value of what's in your bank account because they get $10,000. And it's just got to be what, reasonable value is and what reasonably is in the bank account. And you're not going to have to put on proof showing that there's actually $9,000 in your bank account. It's just that's your protection you get. So you might as well use it. And that way you don't run into a situation where a client suddenly gets an income tax refund and they go over what they had protected in their exemption list. So same thing that I said a minute ago. I don't actually want you to, read this super in depth or anything. This is just showing you what it looks like. This is the administrative office of the courts. Their website has this official form that's for slow pay motion is what we call it. It's technically called a motion for installment payments. And so we'll go into depth on this on the next slide. So the defendant files that form after the judgment is obtained, and most likely after they've actually already been garnished, because there's not really a purpose for it if a garnishment hasn't already started. The affidavit that's attached to the motion, the defendant will list their income and their assets, and the court will review it and determine with the amount that the defendant says they can afford per month. It's up to the judge to say, yeah, you're right, $50 a month or $30 a month, whatever you suggest, that looks like all you can afford based on the information you've given. Or the judge can say, you know what, I think you can actually afford more, and the judge can order more. I've seen a couple of situations where someone was being very generous in how much they thought they could afford per month, and the judge looked at it and said, I don't see any way you can afford this. I think we need to go lower. That's pretty rare, because usually people are putting pretty low amounts on there. The plaintiff has the opportunity to argue against it, but a lot of times they don't even bother to show up to dispute it. Because on the one hand, there's a lot of judges who won't approve a slow pay that's for significantly less than the defendant could reasonably afford, even without the plaintiff saying anything. So for that reason, I mean, why would you show up if you've had that experience before? So unless the plaintiff already has something set on the docket anyway, they might not bother to send an attorney there because clearly this is not an account they're going to be making a ton of money on. to begin with. So it might not actually be justified for them to spend the money to send an attorney there. Once the defendant gets the slow pay ordered by the judge, if they miss a payment, the plaintiff can resume the garnishment, and generally the judge is probably not going to be willing to go back and do another slow pay after the defendant has missed a payment, because what's going to stop the same thing from happening again? And so I always emphasize for my clients, make sure it's an amount you know you can afford. And if you really, really, really can't afford the garnishment, which I mean, they definitely can't, but if you really can't, don't miss those payments. And if you're going to have to miss the payments, get with the creditor and make sure they know that something crazy has happened and you've had some terrible setback and that you're going to make up for it. Try to get something arranged with them, because if not, they're going to resume that garnishment. It's going to be a bad situation. So I'm listing a few case examples of times that I have advise clients who either were judgment proof or weren't, just so you can kind of see some of the fact patterns. And this isn't something where I want people to like volunteer to try to guess. So I've literally put, my analysis on the slide with it. But so this situation, the client had a part-time job and made approximately $250 per week. Client rents an apartment. Client owns a vehicle that's estimated to be valued at about $4,500 and doesn't have other significant personal property. They have a checking account with about $200 in it at any given time. And they were sued by a credit card company and agreed to a judgment of $6,000. No other significant debts, but his family friend told him, you got to file for bankruptcy, and he wants to do it, but he doesn't know if he can actually afford to hire an attorney and file bankruptcy. So my analysis is that he's not actually judgment proof because he could be garnished. But he could file a slow pay motion to get affordable payments. He can protect the limited assets that he has with a personal property exemption list. Doesn't own a home. So with that advice in hand, the client might be able to look at his situation and think, maybe bankruptcy doesn't make sense for me. Maybe I don't really need to do anything other than file these things with the court and protect my income and my assets. And then that's all I really need to do. Obviously, if his situation changes, the advice changes, but this is how I kind of assess that situation and help that client. The next one is a client who was unemployed, but she did draw disability SSDI at about $1,200 per month. She lived in Section 8 public housing, and she had a car note that was approximately $500 per month, and the vehicle was about $7,000. She didn't have any other accounts or cash. All she had was her disability check, and she estimated that her other property was worth about $200 total. So it looks like she was pretty much judgment proof, but the car loan. So that was that threshold thing where if you don't pay that, you're going to lose the car. Private creditors can't garnish her disability, and whatever equity she has in the vehicle can be protected with a personal property exemption list, as well as the other very limited assets. Obviously, no property, doesn't have to worry about liens. With the vehicle specifically, because in this situation, I think she owed very close to I mean, it was probably more than what the value of the car was, what she owed. It didn't really matter, because if a different creditor tried to go after that car, the finance company was going to have priority, so they wouldn't have been able to get anything anyway. But it's just important to note that if they were in a situation where they did have equity, they had almost paid off this loan and they were getting ready to own it outright, then it still, that much could be protected still. Another example is a client who is retired and was drawing Social Security retirement as the only source of income, owned her house outright, but a few years prior to contacting me, she had obtained a home equity line of credit, which is a loan against the equity in her home. And it was for home repairs, approximately $30,000. She owned a vehicle that was worth about $2,500. She had a savings account of $1,000 that she used for emergencies. She had several different judgments against her from credit cards. One of them had filed a subpoena for her to appear in court and answer a debtor's examination. She had previously been advised by someone else that she could just ignore the creditors, um, but she did recognize that a subpoena was a bit more serious, and so she contacted us to see what do I need to do. And she owns her home, so not judgment proof really, but that HELOC loan is probably going to have priority over the other debts. And so they can still place a lien against her home, but there are some practical hurdles for the creditor that it's worth it for the client to recognize that. Um, she can file personal property exemption list to protect the vehicle and her savings account that she has, um, and her income can't be garnished. But she still got to respond to the subpoena, and that's something, that's important for clients to realize is, yeah, she is technically judgment proof, but that doesn't mean that she can't be sued, and that doesn't mean that she can't be subpoenaed. So really, in this situation, it was more of, for these purposes, she's judgment proof for these things, not judgment proof for these things, and then ultimately answer the subpoena. And so that was kind of my analysis for her in this situation. I think this is the last one that I have, and it is a client who is a 22-year-old man. He is unemployed and lives with his family. He doesn't have a vehicle. He doesn't have any cash or any other notable assets or personal property. While he was unemployed and without money, credit card companies, for some reason, extended lines of credit to him. He defaulted on those accounts, and one of those creditors filed a lawsuit against him. He was served with a civil summons to court, and that scared him. So he wanted to know, what do I need to do? What do I need to do here? And I mean, if you look at everything in this example, it's pretty textbook judgment proof, collection proof, however you want to frame it, because there's no income, there's no assets, there's no home, there's nothing. This is like the ultimate you can't squeeze blood from a turnip example, because there's just nothing there to take. But he's young. And so that's something to think about in these situations. Is it'd be different if the client was 70 years old and had these factors, because then it's a lot less likely that the client is going to have a long future ahead of him where things change. This is a client who is 22, maybe finishing up college, probably going to have some sort of employment prospects at some point in the future, if not soon, at least at some point. And so if we say you're judgment proof, don't worry about it, let them get the judgment, they can't do anything. Well, several years from now, those judgments are probably still going to be active. They're probably going to have been accruing post judgment interest. And so it could create a real problem for them later. Now, granted, the other side of that practical reality is there's not really anything he can do because he didn't have anything, but he can be armed with the knowledge that, yeah, there's nothing they can do today to make you pay this judgment, but someday it could create a real problem for you, a real headache. Um, and so that's kind of the analysis that I went through with this client. Was you really just need to know about the implications of what's going to happen later, because it's not going to affect you too much today, but it could have a real impact in the future. So here, and Andy, like you said, is sending out these materials. Just some extra resources if you're ever in one of these situations, dealing with a client who may or may not be judgment proof. Our website, we have lots of brochures and information. I referenced a lot of them in this presentation. We have the personal property exemption list. We have information about garnishments, so any type of thing like that. Also a link to the AOC, because they have the official forms that they use, and it's a good reference there to use that if you need just a blank template. And then NCLC, which is the National Consumer Law Center. If you're not familiar with consumer law stuff, they have a lot of free resources and updates. Also have uh, task force and stuff. I mean, it's just a great resource for really, really good consumer lawyers who are willing to help folks. And so that's a resource if you ever want to. It's kind of more getting in depth on the stuff. I got my contact info up here. If you ever have a weird case and you want get input from me, I'm happy to talk to folks. Got my number and my email. And this is stuff that's going out. Probably, I think Andy's already sent it out, but it's also in the chat. And so that's my presentation. I appreciate the opportunity to come and talk to you guys. I'm happy to field any questions or discussion or anything like that.
If you have any questions, go ahead and put them in the chat for Jake. While people are doing questions, just want to let everyone know that we are in the process of planning clinics and have worked on some statewide pro bono clinics to help people who are a lot of times people do call our office saying they want to file for bankruptcy. And many times Jake takes those cases, looks at them, and it's like, oh, you actually don't need bankruptcy. But there is only one of Jake right now, and not multiples. So we are in the process of planning some more clinics that volunteers can join virtually with the bankruptcy judge actually usually involved to be able to talk to the clients and look through their debts and figure out and examine to them or examine and let them know if they do actually need a bankruptcy so we can then refer them to a bankruptcy attorney or if they are judgment proof or any um, other reasons why they shouldn't file for bankruptcy. So if anyone's interested in helping on any of those virtually, you can sign up in the CLE form for assistance on clinics, and we'll be in touch. But I'll give it a few more minutes for anybody to ask any questions in the chat. Before we move on to the next presentation, which we do have to wait for them to join the meeting. So we have some time for people. Sarah King, Sarah, I'll go, she raised her hand. I'm gonna go ahead and allow you to talk. You can ask the question and then we'll move you
Hey,
back.
it said my chat was disabled. Sorry.
Oh, no.
I just had a question about notices from the IRS. How do you get a collection hold when the IRS you owe to the IRS and it's not a private creditor? Because that system seems so hard to navigate, getting to anybody who can actually help you. And then I know that Jake had said that it's unlikely people or private creditors will levy. Is that different for the IRS and the government?
Yeah, so I mean, I think it is different for the government. But it's going to be case by case with the IRS stuff. So I'm trying to understand exactly the question. Um, how does it get to a point where that's happened? Is that
No. So like there is a debt owed to the IRS. They're accruing penalties, and they're pretty significant. And the IRS finding a way to get a collection hold, which is my understanding of what you have to do to get them to just stop and talk to you. But how do you get to someone? Like, who's the person in the IRS you talk to try to negotiate a settlement? Because it is so different than a private creditor. And then also when they send out this notice of intent for a lien, are they more serious than like medical collections would be?
yeah, they're definitely more serious. The IRS is actually scary, I think. But yeah, I would say I don't know that there's a magic person to get who will be able to help. Um, I don't know. I mean, that's like a very fact specific thing. I hate that I don't really have a good answer for it. It's a really good question. I do think the second part though, they definitely treat things differently. I don't have a ton of experience with um, handling stuff with the IRS because a lot of times it'll be weird tax issues that are a little bit outside of my expertise, and I will refer my clients to specific tax attorneys. But for something like that, I don't know. It's actually kind of shocking that you wouldn't be able to get to someone. yeah, I don't really have a good answer for that. Sorry.
No, that actually is helpful. Yes. You know, just I'm thinking of situations where it's not like with the private creditors, you get to go to court and talk to an attorney or someone who's there to manage it and sort of resolve it, but also somebody who doesn't have a lot of assets, but maybe is in their mother's home, you know, and they do have a significant asset, but if they had to sell it to pay the debt, would essentially be homeless. So I know there's a process for it, but I was just wondering if it was the IRS cared a little bit less than the private collections did, and it sounds like that's the answer.
Yeah, yeah, and it definitely is case by case. I mean, it depends on what the situation is, but and how much is owed. I mean, really, but yeah, that's kind of all I got on that.
I fixed the chat, so people should be able to add questions in there. I apologize that it was not working. Anybody else have any questions for Jake? All right, well, Jake, thank you. We'll wait a few more minutes before we start our second session. If anybody has anything else come in, feel free to ask. But we'll take a quick break and start up at 10:30.